Good afternoon. I hope you are doing well. My name is Katie Cush, and I am an Alumni Relations Officer at RISD. Thank you so much for joining us for today's webinar, A Fairly Useful Guide to Fair Use. Before I introduce today's presenter, I'd like to go over a few things first. Today's webinar will run roughly about 45 to 50 minutes, leaving us some time at the end for Q&A. If you do have a question, feel free to post it in either the chat section or the Q&A box, and we will do our best to address all of them at the end. A recording of this webinar will be posted on the RISD alumni website within the next 10 days. So if there's anything that you missed or you have a fellow alum who would like to learn more about fair use, please encourage them to visit the RISD alumni website, which is alumni.risd.edu. And if I could just ask everybody to take a quick moment, make sure that their microphones are muted before we get started, that would be wonderful. I'd like to introduce you to today's presenter, Greg Kanaan, who is a fellow RISD alum. He graduated in 2002 from the FAV department. Greg is a New England-based attorney who focuses on intellectual property, business law, and contract issues for artists, filmmakers, and creative entrepreneurs. On top of providing legal services and counsel to a wide variety of creative people, Greg regularly speaks at colleges, nonprofit art organizations, and professional associations about how the law affects their artistic endeavors. Greg writes for a variety of publications, and he is the founder of the blog The Legal Artist, which was chosen in 2005 by the ABA Journal as one of its top 100 legal blogs. Before earning his JD from Northeastern University School of Law in Boston, Greg did receive his BFA from RISD, and he was a documentary television producer for 7 years, working for the Discovery Channel, TLC, Court TV, and A&E. Greg is licensed to practice law in New York, Massachusetts, and Connecticut. And so with that, I'd like to turn it over to today's presenter, Greg Kanaan.
Thanks, Katie, and thank you everyone for making time in your busy lives to come and listen to me talk about legal stuff. I wanted to come up with a topic that I think would be widely applicable to a wide variety of people in creative fields, and I think fair use is that topic. It affects pretty much everyone, regardless of what you do, regardless of which creative field you focus on. So I figured it would be a good time to do that today. Before we get into the material, Katie did actually a pretty good job of introducing me, but thought you might want to see that in person. Yes, I am a RISD grad as well as a lawyer. And believe it or not, there's more than one of me. There's actually about 30 of us, and we have our own RISD Affinity alumni group, of which I am the group leader. So, so there's a handful of us. I think I'm the only one who focuses exclusively on issues related to artists and designers and filmmakers, but yeah, there I am. I as Katie mentioned, I was a TV producer for about seven and a half years. I did a number of things for Discovery Channel, TLC. I split my time between Los Angeles and New York. And then in 2009, I switched paths. I went to law school at Northeastern in Boston. If you're interested in that particular topic, I actually just hosted a webinar that's on the RISD alumni page. So if you're interested in pursuing a career in law or public policy, you might want to listen to that. We just did that last week. Or you can just email me. My contact information will be at the end of the webinar. And you just want to pick my brain, I'm happy to talk about it. I am licensed to practice in New York, Connecticut, and Massachusetts, and my law practice does focus mainly on entertainment and art law. But I do intellectual property and a lot of business-related legal counsel as well. If you've been to one of my webinars or my seminars, you've heard this caveat that I give out at the beginning of all of them, but I'll just do it again here for those of you who are new. I'm going to be giving you legal information, not legal advice, and the distinction there is that it doesn't create an attorney-client relationship. If you want to create an attorney-client relationship, you can reach out to me after the fact. This is going to be the agenda for the next 45 minutes or so. I'm going to talk about fair use as it relates to the world of copyright, which is the bulk of it. I'm also going to spend some time talking about misconceptions and things that people don't really understand about fair use. And then I'm going to spend a little bit of time at the end of the presentation talking about the fair use implications of trademark. You'll see fair use is in quotation marks there. There's a reason for that, and we'll go into that briefly. And then at the end, I'm hoping to leave some time for questions and answers, because this is a topic that I typically get a lot of questions about because it is hard to understand. So what is fair use? Well, in coming up with this presentation, I wanted to come up with the simplest, most easily understood definition of what fair use is. And fair use is the lawful use of another person's copyrighted work without their permission. In other words, it is the legal right to infringe someone's copyright, even if they don't want you to have that right. That's it. That's what fair use is. Pretty simple, right? Well, that's where the simplicity ends, unfortunately. I want to pause on this image and let it sear into your brain. Fair use is actually a pretty dangerous concept if you don't know what you're dealing with. Why is it dangerous? Well, for all of these reasons. I think it's largely misunderstood. It's largely used as a crutch, especially in the internet age. We'll talk about that in a moment. It is difficult to apply. I'm gonna spend a good portion of this presentation talking about the fair use factors and why it's not simply just a bright line between something is fair use and something isn't fair use. As I mentioned right at the top, fair use affects pretty much all artists. It affects you whether you're the person using the copyrighted work or you're the person whose work is being used. If you're a person in a creative field, fair use affects you to some degree in your life. It does put you at risk of a lawsuit. I will touch on that a little bit later. There are no easy answers with fair use. I think the question I get the most is this fair use or not? And it's almost never that simple. And lastly, it can be really, really costly. I'm gonna talk about the financial implications of being found not to have fair use applied to your use of somebody else's work. So bear with me on that. I do want to pause on this issue. The problem with internet culture is that it's really easy to steal or use someone else's work without getting their permission. I think having so much data, so much material at your fingertips is actually a really bad thing when it comes, at least from a legal perspective. And when I was coming up, if you wanted reference material, you had to go to a library, or you had to go to a museum, or you had to go sit outside in nature. And nowadays you can just go online and look up a picture and then copy it. And in many cases, artists don't just copy it, they just take it outright and repurpose it. You see this a lot on Instagram, you see it a lot with memes. And so there are larger legal questions surrounding how whether those uses are fair use, and each one is its own kind of thing. So we'll talk about that. I mentioned earlier that fair use is dangerous, and this is a good example. I don't know if you remember, but back in 2013, Robin Thicke, T.I., and Pharrell all released this hit song, Blurred Lines, and when they released it, they were very public about wanting to pay homage to Marvin Gaye's Gotta Give It Up. And it wasn't just an homage. They said they want to honor Marvin Gaye. Well, it turns out that Marvin Gaye's estate really did not think that was appropriate. They said, well, this song is too similar to the one Marvin wrote. And in fact, it's so similar that it constitutes copyright infringement, and we want you to pay us. Well, there was a big lawsuit between the two parties, and ultimately it ended up with Robin Thicke, T.I., and Pharrell owing the Marvin Gaye estate about $5 million, and then he had to credit Marvin Gaye as a writer on the song, on Blurred Lines, because they said the song essentially was a copyright infringement. It did not constitute fair use, which was the argument of Robin Thicke and company. So you never quite know, even if your intention is pure. I'm intending to honor this person, I'm intending to homage them. It still could be found, it could still backfire spectacularly. So you have to be very careful. I want to pause on this moment too, this topic. You've all heard this phrase, it's easier to beg forgiveness than to ask for permission. It was a phrase that was coined by Grace Murray Hopper, who was a Navy admiral. And more than being a Navy admiral, she was in fact a computer scientist. So she was a woman, who had attained a high rank in the military at a time when most women weren't even allowed to be or were just secretaries. They weren't allowed to be in the ranks. And here she was, an admiral, a computer scientist. So when you think about her life and her context, and I'm not going to get into it right now, but you definitely should read up on her. She's a very impressive lady. But when you think about her life, it makes sense that you'd want to just take what you think is yours and deal with the ramifications later. And I get that, but in the legal world, and especially with regards to fair use, it's a bad it's bad advice. And in fact, I always tell clients and people who ask, don't beg for forgiveness, ask for permission. Instead, I'd rather you think about Weird Al Yankovic. I think it's kind of a strange way to go, but I ask, what would Weird Al do? And what Weird Al would do is actually very clear. Weird Al has stated on numerous occasions that he does not use work without getting permission. And if he cannot get permission, he doesn't use the work. And according to him, he feels like at least part of the process, or at least part of the point, is the artist being in on the joke. And so he asked for permission all the time. And in fact, there was a whole thing with Coolio about, if you remember back in the mid-90s, he did a spoof of Coolio's Gangster's Paradise. And he thought he got permission. It turned out he didn't. Coolio was pissed off. There was some kind of fight in the press about it. Weird Al backed off. But he's a guy who I think when it comes to using other people's work, he's a good role model. So that's like the basic gist of fair use and why it's difficult to understand. And we're actually going to get into sort of drill down into the detail a little bit more. The thing about fair use, as I mentioned before, again, is there's no one right answer, and there's no definite yes and definite no. The way you determine whether fair use applies to your use of somebody else's work is we apply the 4 factors. And these are written into the United States Copyright Act at 17 United States Code, Section 107. So fair use is actually written into law as something you can do. And you have to take these 4 factors and you balance them against each other. So you're not trying to meet each one of them. You're looking at how your use implicates each one of these factors, and then you make a decision. Usually that person making a decision is a judge or a jury. And I'm going to sort of go into each one one by one. So the first factor is the purpose and character of the use, including whether or not such use is of a commercial nature or is for nonprofit educational purposes. This is maybe the most invoked factor because it's the one that gets at the heart of fair use, or one of the hearts of fair use, which is, does your use of somebody else's work transform the meaning of the original work? The more your work is transformed, the more the work is transformed by the way you use it, the more likely fair use will be considered. So, I think a lot of people are concerned about the nonprofit, the financial implications of this factor. And they say, well, if I'm using somebody else's work, but I'm not making money, does that mean it's fair use? And the answer is maybe, maybe not. It really depends on the context, how this factor and the other 3 factors apply. Financial benefits are an important part of United States copyright law, but it is not the only factor to consider, and it's certainly not the most important factor. So I just want you to keep your mind on, keep that in mind, I should say, when you're thinking about using somebody else's work. Just because you're not making money doesn't mean you're in the clear. I'm going to break this down a little bit by using some examples. Most of the common examples of a transformative use are, so as I said before, something that's non-commercial. So while you could still be found to be in violation of somebody else's copyright, if you're not making money off of it, that is still a factor that is considered by the courts. If you're doing something that's parody is widely considered to be a fair use. News gathering, the nature of news gathering is such that it steps aside from copyright infringement concerns. So usually because of the fact that it's so timely, timeliness is a factor. If you're criticizing, if there's criticism or commentary about somebody else's work, that's often considered to be fair use. So movie criticism, for example, would be, or, movie criticism. Using something for educational purposes. All these images that you're seeing on your screen are copyrighted images. But because I'm putting them in the slideshow for educational purposes, it is likely to be a fair use of that. And then, of course, anything in the public domain. I mean, anything that is no longer legally owned by an entity, you're free to use. Let's talk about the Obama Hope poster. Shepard Fairey, who himself is a RISD grad, took this image, found an image that was taken by AP photographer Manny Garcia in 2006, then Senator Obama, who was either at a campaign rally or he was at something, but he snapped this photo. Shepard Fairey found the photo and turned it into the infamous Hope poster. At the time, the AP said, well, that's our copyright. and they threatened to sue if Ferry didn't pay them. And so Ferry actually preemptively sued them, claiming that he had fair use. And ultimately, the court didn't decide because they settled out of court, and it was a secret settlement. So nobody knows exactly what Ferry paid or how it was resolved. But the question at the time was, does Ferry's use of the image transform, does the way he uses it transform its meaning? And I think in 2008, that question was largely unresolved. I think if you were to ask me, I think you could make a credible argument that the way Ferry used the photograph was sufficiently transformative to qualify for fair use. But I think you could also make a compelling counter argument. But what about today? I mean, that poster is ubiquitous. It's everywhere. And in fact, it's been memeified to the point that the very concept of what Ferry was doing has become its own style, its own thing. So I think even if you could make an argument back in 2008 that it didn't qualify as a fair use, I think it would be harder to make that argument today, given how memeified and how popular it's become. Let's talk about factor two, the nature of the copyrighted work. What that's really saying is the work fact-based or fiction-based? Is it published or unpublished? Fact-based and published works lend themselves to fair use, while fiction-based and non-published works do not. Let's break that down a little bit. Fiction versus nonfiction. Historical facts, historical figures, historical events are not copyrightable. This is why you can have hundreds or thousands of books, movies, TV shows about Abe Lincoln, about his life, because he was a figure, he lived, the facts about him are not in dispute, and you can interpret those facts in different ways, and that interpretation would qualify for copyright protection, but the facts of somebody's life are not. However, if you were to say, I want to write a movie screenplay about Abraham Lincoln hunting werewolves, well, it turns out there was a book and a movie about a fictional book and movie, I should say, about Abraham Lincoln fighting vampires, and that would not lead itself to fair use. That would more likely be a copyright infringement if you were to do something like that. Published versus unpublished. There are two photographs here. One was taken by me. One was taken by a friend of mine who's a professional photographer, both of the Boston skyline. And the only real distinction here is that my friend Alex, who's a photographer, had his photo published in a magazine. My photo has never been published anywhere. That's just something I took with my phone several years ago. An unpublished work is harder to apply fair use to because it's not used anywhere. It's except in the artist's portfolio. So acquiring access to that portfolio indicates a more willful attempt to use that work that isn't out there in the public sphere, and courts really look down on that. So, if you're going to use a work, make sure it is published. There is a larger question about what published actually means. I mean, so in some places it's pretty obvious. So again, my friend's photo here had been published in a magazine. If you were to find that, it would be pretty obvious that it was published, and you could then fair use it would apply to it. But here's another question. Does me putting my photo in this presentation constitute publishing? I don't know. The courts haven't decided that yet. And to be honest, it's a question that hasn't come up very often in the case law. So it's an open question. Factor three, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. This is actually one of the easier ones, and it's not litigated on very often. The less of the original work you use, the more likely it's going to fall under fair use protection. But if you use the heart of the work, fair use is not applicable. What does heart of the work mean? Well, heart of the work means that if you separate it out from the work basically does not stand on its own. So let's say you wanted to write a song about how you can't get any satisfaction, and you were to write a lyric in there that says, I can't get no satisfaction, and then you were to copy the opening riff from the existing song, I can't get no satisfaction. That would be considered the heart of the work of that song, and that would not be a fair use, an appropriate fair use. And last but not least, factor four, the effect of the use upon the potential market for or value of the copyrighted work. What does that mean? Well, copyright law is largely about protecting the owner's financial rights. if you could deprive the artist of actual or potential financial gain, then it is not fair use. So you remember when I said earlier that when we talk about money, the issue isn't, you may not be making any money, but the issue isn't necessarily, are you making money? I mean, that can be an issue, but the real issue is, are you depriving the owner of money that he or she might otherwise rightfully have? Even if it's from an avenue that the owner wouldn't necessarily think to exploit. And I'm going to use this example to illustrate that point. There was a photographer named Art Rogers who took this picture, the one you see above, the black and white photo. And Jeff Koons, who is like a renowned like artistic troll, I guess you can call him, he found this postcard with his photo and said, I think these would make great sculptures. So he created these wood sculptures. You see a picture of one below there. And he made over $350,000 from the sale of those sculptures, which is astonishing considering how ugly they are, but he did. So anyway, Rogers sued Koons for copyright infringement. And Koons admitted to using the photo without Rogers' permission in court, but he argued, among other things, that the sculptures were fair use because Rogers was a photographer and not a sculptor, and he never would have thought to make sculptures and profit off of those. So what did the court say? Well, unsurprisingly, maybe, the court found against Koons. They said his fair use argument didn't hold water. And they said that even though, first of all, it didn't constitute parody, which is one of his arguments. It was not a parody. But they said that even though Rogers was a photographer and didn't necessarily intend to make money from turning that photo into sculpture, he could have. And that's why it wasn't a fair use. So even a potential avenue, even disrupting, I should say, a potential avenue of profit for the owner might be enough to find you in violation of their copyright rights. So what should you do? Well, you want to decide if using the work is important. And I think that's a question you want to dwell on quite a bit because, why are you using the work? Is it something you have to do? Is it something you're being ordered to do by a superior or a boss? Is it something that you're doing out of laziness? Is it something you're doing because you are trying to make a comment or you're trying to criticize that work? I think your motives and your intent are actually really important in this issue. Intent is not something that shows up in the law very often, other than in criminal law. But this is one of those areas where your intent is actually really important and can make a difference between you being, you owing the original owner, several $100,000 or having it be considered a fair use. So that's something you really need to think about very long and hard about. If you decide you have to go forward with it, make a good faith effort to get permission. What does good faith effort mean? Well, you have to make a concerted effort to find the owner of the copyright. You have to try to get in touch with them. You have to make several attempts. You should probably document your attempts if you're doing it by phone or some other non-written way. You have to do the work. And if after doing the work you can't find them, you made good faith attempts to find them online, you tried calling, you tried emailing, you can't get through to them, you can't get an answer either way, then you've at least done your due diligence and you can move on to the next steps here. But definitely make that attempt. If you do get a no, if you make an attempt and they say no, absolutely not, do not use the work. I can't actually stress this enough. If you get a no and then you still use the work after they've said no and you've tried to negotiate and they won't play ball, walk away, because you could be on the hook for something called willful copyright infringement, which under the US Copyright Act could put you on the hook for a minimum of $150,000 per infringed work. So if you're doing if you use multiple works without permission, and this person has said no 3 different times for 3 different works, you're looking at almost $500,000 worth of statutory damages. So you really have to walk away. It's very hard in court to prove willful infringement, but if they can document that they've said no to you and then you still use the work after that, that's pretty compelling evidence. Again, if you can't get an answer, you have to weigh the risk. I don't think anyone should enter into this kind of thing very lightly. I'm a lawyer. I'm very conservative, not politically, but at least with regards to protecting my clients' rights. And I think that not using the work is probably safer than using the work. And if you have to use the work, you really do need to weigh the risk to yourself, to your client, to whomever you're doing the work for. Again, take it seriously. Don't just assume your use is fair. This is something that happens quite a bit when clients contact me after the fact. They've used somebody's work. Somebody said, hey, you're infringing my work. Now what do I do? I know they say, oh, well, I thought it was fair use. Well, why did you think it was fair use? And they give me some kind of, half-assed answer where they say, well, I'm not making that much money. And, I found this guy's AOL address and then it got bounced back to me. So I didn't, there's always some kind of excuse. And it makes my job harder to defend that person. And you just don't want to be in this position to begin with. So please take it seriously. And ultimately, if you have to use the work, don't make the assumption yourself that it's fair use. Talk to a lawyer, talk to me, talk to somebody else, talk to somebody who knows the issue. Because as I said before, as you can see now, it's not just yay or nay. It's, okay, well, what about this factor and this factor? And how does it, interact with these factors? So something to keep in mind. There is ultimately only one truly safe way to prevent a copyright lawsuit, and that is you need to get permission. And that is the only foolproof thing you can do. Get permission. You might have to pay for it. That may be okay. It may be worth paying a little bit now to have the permission for later. Let's talk about common misconceptions. These are the questions that I get most regularly about this issue. And so I wanted to sort of break them down one by one. If I use something old, no one will sue me. Well, maybe, but just because it's old doesn't mean it's in the public domain. If it was made after December 31st, 1922, someone could still own it and they could sue for copyright infringement. So you want to stay up on what's being released into the public domain. I believe it was recently just announced, or not recently, but last year it was announced that anything made after 1924, made before 1924, is now into the public domain. So they're starting to inch up the years every year now. So you want to keep an eye on that. So if I credit the artist, I don't need the permission. This is something I hear quite a bit, and it's not true. You absolutely should credit any artist whose work you use. Whether or not they ask for it, it's just good karma, but it doesn't have any legal bearing on whether or not it's fair use or not. So remember that the crux of copyright law is economic gain, not credit. That's not always the case. In Europe, there are these things called moral rights. And the idea there is that your reputation as an artist is more important than, is at least as important as your financial ability to profit off of the work. So that's not the case here in America. Under American copyright law, it's about money, not credit. If I can't find the artist, I won't get sued. I've heard this one a couple times, and like the others, it's not true. You should always make the best effort you can to find the artist and get permission. Just because they're hard to find doesn't mean they can't find you. This actually happened to a friend of mine. I have a friend who's a painter. He's pretty well known, and he wanted to, I'll use the word homage again. He wanted to homage another renowned painter who was at the time quite elderly. And he tried to find the painter online. He had no online presence. And after what I thought was not enough sleuthing, he decided, I can't find the guy. He might even be dead by now. So I'm going to go ahead and do my painting. Well, guy does his painting. He posts it on his website. He actually, I think, ends up licensing it for use in a magazine or something. And the artist's son finds him. So, and then they have a whole back and forth, and I have to get involved and help negotiate some kind of settlement, which we do. But just like, remember, just because you can't find them doesn't mean you're not findable. So watch it out. I've talked about this one ad nauseum at this point. If I don't make any money from the use, then it's okay. Maybe the most common thing I hear from artists, again, possibly, but remember, your ability to make money off of that work is only one of the factors. And you can still be liable for infringement even if you make no money. So just be careful. And here's this is one that affects artists whose work is being done. So if you find yourself on the other side of it, you say, you know what, my work is out there, but I don't want anyone else using my work. I'm going to put a disclaimer on my website saying this work is not for use, is not available for fair use. Well, you can't do that. Fair use is actually a right granted on all copyrighted work. Like I said, it's written into the law there. It's in fact 107 is one of the first provisions of Code 17 of the Copyright Act. So when Congress wrote the Copyright Act in 1976, they were thinking very seriously about fair use, to the point where they felt it should go way up front. So you cannot prevent others from using your work as long as their use of your work meets the 4-factor test. It doesn't infringe any of your rights. They can use it and you can't prevent it. Last but not least, claiming fair use will protect me from a lawsuit. If you guys get nothing else from this presentation today, please let it be this. Fair use, while it is a right granted to you under the Copyright Act, is not a shield that protects you from consequences. Fair use is called an affirmative defense, which means you can only use it after you've been sued. This means that you've received a court summons, you've received what's called a complaint from the person who claims you're using their work, and then you have to hire a lawyer and you have to appear in court, or at least your attorney has to appear in court on your behalf, and they have to write an answer or a brief saying that fair use is your defense. And then once you've asserted fair use as your affirmative defense, then you have to go through the whole judicial process. And through that process, most judges will try to get you and the other party to settle, which means that even if you are right that fair use applies and that you could have done fair use would have gotten you off scot-free, you may end up actually having to pay this other party something, because judges hate going to trial. This is something that you don't hear very often in the television and the movies, but judges don't like trial, and they're always forcing parties to try to settle. And in fact, I've been witness to a judge forcing parties to settle in the middle of trial. So he'll just say, go to the chambers and don't come out till you have a settlement. In the middle of a trial in front of a jury. So I've seen that happen. So even if you're right and fair use does apply, there's a very good chance you are shelling out money to hire an attorney to defend yourself and then get forced into a settlement, even if you're right. So this is one of the reasons I don't like fair use, or at least I don't like it when artists use fair use without thinking very long and hard about what they're doing and why they're doing it. That is the end. Believe it or not, we've only half an hour in and I've blown through the copyright portion of it. So I'm going to talk briefly about the trademark stuff, and then we can go right to questions. But before I do, I want to just draw a distinction between copyright and trademark, because I think that while they do overlap, a lot of people aren't entirely clear on the distinction. Copyright is just a term for the suite of rights you get to exclusively own and exploit, or to give others the right to own or exploit what we say, this is the language of the Copyright Act, any original work of authorship fixed in any tangible medium of expression. What does that mean? It means art. Anything written down, anything recorded on film or an audio format, anything drawn, painted, you name it. Most artistic things would be covered by copyright. Trademark is, again, a term for the exclusive legal right to own, exploit, or give others the right to own or exploit a mark, logo, slogan, phrase, visual brand identity, and commerce. So, think of brand loyalty, that kind of thing would fall under trademark. Design and art would fall under copyright. The reason I bring that up is because trademark fair use, while it's very similar to copyright, is not really that similar. I mean, it functions the same way. It has the same effect, I should say, which is that you can lawfully use another party's trademark without their consent, but it functions in a very different way because it's a totally different law that addresses totally different things. And by the way, fair use is in quotations because fair use is not an actual term we use in the trademark world. It's a colloquialism that we brought over from copyright just because it was easier. It's a shorthand, but there's no actual term trademark fair use. And there's really three forms of trademark fair use. This is the actual language of the Lanham Act, which is the trademark law, at 15 United States Code, section 1115. I'm not going to read it because it's boring, but I will summarize them for you. One of the main ones is a descriptive use. Some trademarks use existing words to describe a characteristic of their product or service. These marks contain words that have primary meanings, which are then refashioned to have a secondary meaning. So as long as you stick with the primary meaning of the words, trademark fair use applies. So Best Buy, right? The words best and buy existed before the brand did, didn't they? And they meant certain things. And at some point, this company came along and they said, well, we want to use the words Best Buy to describe the quality of your shopping experience, the quality of our pricing. You will literally get the Best Buy in our stores. So the words best and buy had meaning before Best Buy appropriated them to mean something else. But as long as you use the words Best Buy and you're not referring to the brand, then you're fine. You're okay. That's considered trademark fair use. There's actually one exception to that, which I'll get to in a moment, and will make more sense when I do it. Comparative use probably won't apply to most of you unless you work in the advertising world. But if you've ever wondered why Coke and Pepsi or other advertising brands can call each other out publicly in commercials, you've probably seen the Coke and Pepsi, some version of the Coke and Pepsi taste test commercials. You see it a lot with toothpaste commercials where they'll hold up two different, their brand and the competing brand. The reason they're able to do that is because it is permissible under the trademark law to reference a competing mark by name for the sake of comparing their brand against yours, as long as the ad itself isn't deceptive. So for example, it is permissible for Coke and Pepsi to call each other out by name to call attention to the distinction between the two beverages. And that's because they're not actually trying to exploit the competing mark. Coke is not trying to associate itself with Pepsi. It's in fact trying to do the opposite, right? It's trying to show why it's so much better than Pepsi, and Pepsi's customers need to come over to Coke. And last but not least, this is maybe the most common trademark fair use, is nominative use. This is where you're simply referring to the existence of a mark or its products or services without using the mark for its commercial appeal. That's considered a permissible nominative fair use. So for example, simply referring to the existence of Sprite doesn't mean you're trying to appropriate the mark or convince others that Sprite has endorsed you, right? If you watch a TV show and a character is drinking a Sprite or Diet Coke, it's possible that the production company has a deal with the beverage company, but it's also likely that it's just a Diet Coke can that was sitting in the background. And as long as that's all it is, they're not trying to say, look at this Diet Coke here, and trying to exploit the can or the mark or the brand for their own use. That's fine. That's permissible. And the reason it's permissible is because we live in a world where branding and content is everywhere. It's staring at us from every angle. And to prevent us from mentioning any marks or brands simply because permission wasn't given would create a dangerous slippery slope. I'll just tell a brief story from my own experience. Back when I was producing, I was in Louisville, Kentucky, and I was leaning out of a car, shooting another car, shooting B-roll footage of, driving down the highway. And in the background was, you'd see zooming past, you see Kohl's and Starbucks and Best Buy and Target and Walmart and, KFC. And, you see all these brands and the billboards and the logos in the background zooming by. And I remember when we were editing the footage a month later, we did a rough cut, I should say. And, some of those, driving down the highway shots ended up in there. And we sent the rough cut to the network for review. And then we also sent it to our lawyer to do a legal review. And he came back and he said, this entire shot needs to be blurred out or you need to change the shot. I said, well, why? I was a young associate producer at the time. I didn't know anything. It seemed ridiculous to me. And he said, well, you don't have permission from any of those brand logos you saw in the background of your shot. And you're not going to get it. Like, this is a tiny, no-budget documentary show for Court TV. I mean, it has a viewership of like 200,000 people. Like, you're not going to acquire those rights because those rights are too expensive. So you should just either edit out the shot or blur it into oblivion. And we did. We blurred it and we moved on with our lives. But ever since then, I felt like this doesn't make any sense. These brands are just out there. Like, why is it wrong for us to show a shot we're not advertising the brands. We're not associating with the brands. We're not endorsing them. Or we're not telling people they endorse us. They're just there in the background. Well, I think now that I'm a lawyer that I was right and he was wrong and he was being overly cautious, which I understand. And I know it sort of cuts against what I said earlier about lawyers, including myself, being conservative, but here we are. I think the law really backs me up on this. So that, believe it or not, ladies and gentlemen, is the end of my presentation. That was 40 minutes. We have some time for questions. And if you need to get in touch with me, this is my contact information.
Great. That was great. Thank you so much. You flew through that. I like it.
A lot faster than I expected.
Good. Well, that gives us just more time to field some questions. So we have some coming in. So the first question is, can you talk about using other people's photographs to make your own collages?
I can, yeah. I mean, so nothing I've said so far really, I should say nothing I would say about that is different than what I've already said, which is, if you're using photographs that you didn't take and you don't own the copyright to, it doesn't really change the calculus. I would add, however, when you're dealing with compilations, that's what we call a derivative work. And there are certain types of derivative works like compilations where you can own the copyright rights in the compilation itself, but not the underlying work. So if you take 10 photographs and they're all from different artists, you're going to have 11 copyrights. You're going to have the 10 copyrights from the 10 different artists, and then your copyright in the compilation, because under copyright law, you actually have artistic rights in the way you assemble other people's work. So that is considered its own form of expression under the Copyright Act. So you would still need to acquire those rights in some way, assuming it's not public domain. Unfortunately, it doesn't. You can't just exploit it because you took it and mushed it together with a bunch of other people's work and hope that gets you out of jail, essentially, because it doesn't. It unfortunately doesn't change the underlying analysis you have to do.
Okay, great. Thank you. Our next question, Jasmine is wondering how the law applies to products that are quote unquote inspired by works protected by copyright.
I mean, it's a tough question to answer because, you could have a Robin Thicke situation, a Blurred Line situation where you are saying this is inspired by, this is not a copy of this song. I mean, I remember listening to that song, and then when the controversy came up, I listened to the Marvin Gaye song and I said, well, I can definitely hear an influence, but if you're telling me that these are so similar that they're almost the same, I don't buy it. And I still don't buy it. I'm not a fan of Robin Thicke. I'm not a fan of that song, but it's just not clear to me that they're so similar that it's functionally copyright infringement. And yet a court found several times, by the way, that it was infringement. And to the point where that they made the writers, credit Marvin Gaye and pay his family $5 million. So simply claiming that you're inspired by a thing is not, I don't think is going, at least legally speaking, is not a sufficient defense. I don't think that's the kind of thing that gets you out of being sued. It doesn't mean you will get sued, by the way. I mean, there's plenty of people who claim, oh, you copyrighted my work and then don't act on it. But it's not simply claiming, inspiration or homage or anything of that sort is not going to be enough to prevent you from being sued, unfortunately.
Yeah, I never heard the. Oh, sorry. Go on.
No. What did you say?
I was just gonna say I never heard the correlation either between the song, what you were saying before about the songs. I never heard it, but I guess the courts did.
Yeah, it's shocking to me. But I will say this. Courts in general, most judges are old white men who don't know anything about technology or modern culture or history or anything like that, or what's the word? Entertainment. They don't know. So they could hear things that just really aren't there. This is one of the reasons why in trials you have experts testify to things, but sometimes it's not enough.
Gotcha. Eliza has a question. They have a bit of a situation that they'd like your take on. They had an incident where someone bought their work. It's a fabric textile design. The person photographed it and they used it in their book. They did not ask for permission, but they emailed to tell them about it later. Is this fair use on their part because they bought and photographed it? The design is credited to my organization, but they did misspell it because they didn't check with us first.
Okay. I'd have to think about that for a minute. Yeah, Eliza, why don't you email me after the fact? We can talk about it.
I'll copy that question down too, so we have exactly what it is that she was asking.
Yeah.
Okay, give me one moment. Let's just move on to the next question. Eliza, if you need Greg's email address, you can feel free to email me, or if, oh, it's right there on the screen, so never mind. Um, so our next question, M. Becker is wondering, what if a designer on my staff finds an image of a good-looking chair on Pinterest and has a factory make a very close copy of what was in the image?
You're probably skirting a line, but you might be okay. I think I want to draw a distinction between using somebody's work in your work and using somebody's work as like reference material. That's not the same thing as using it as inspiration, because inspiration tends to be, I'm taking this, or at least the way it plays out legally is, I'm taking this work and I'm adding to it or expanding from it. Whereas reference material is, I need a picture of something so I can do my own thing to get a sense of size, proportion. You know, you're not necessarily copying that person's style. So I think you might be okay. I'd kind of have to see it to get a better sense. I mean, the closer it is, the less likely it's fair use. The issue isn't really the picture versus the product. It's what the two products look like together. I mean, if your chair is so similar to the chair in the picture, you're not necessarily infringing the picture, you're infringing the chair. So how similar and or I should say how dissimilar it is going to be key to determining whether it's fair use or not. But using an image of a chair as reference material to do another image of a chair would probably be okay.
Okay. Liz has a question. She's wondering if you could talk about fan art. Many people sell their interpretation of characters as prints and on merchandise. Where does this fall legally?
It's bad. Not great. Like don't do that. You're cruising for bruising if you do that. There are actually attorneys. I'm not one of them, but there are attorneys who specialize in fan art and fan fiction and that kind of stuff. It's copyright infringement. I mean, if you're just because you drew a picture of Batman and it's your own picture, doesn't mean it's okay because you drew it from memory and you put it on a shirt and you sold the shirt. Like, it's still Batman, and Batman is still owned by DC and Warner Brothers, and including the way he looks. So even if you draw Batman in a pose that you're certain has never been done before, let's say for the sake of argument that no one has ever drawn Batman in this pose before, it doesn't matter because you didn't copy it from another picture. You're still copying Batman, and you don't own the rights to the character anyway. So don't. I mean, making money off of your use of somebody else's work. If you don't make money, you could still be sued, as I've said before. But if you do make money, you definitely will be sued. Like, you're definitely in trouble. So don't do that. And I can't stress this. It's really bad. Like, especially like if you're doing characters that are really well known, like Superman, Batman, Spider-Man, Hulk, X-Men, Marvel characters, DC characters, Avatar, you name it. If it's like a big franchise, definitely don't do that. You're in for hurting if they find you.
Virgil has our next question. They started out by saying, Greg, fantastic session. I teach a graduate design class, and my students frequently publicly post their assignments, videos, interactive designs, infographics, data vids. They post them publicly, which sometimes include corporate logos or images that they find online. Could you discuss how fair use applies or doesn't apply given nonprofit educational use if it's just one factor?
Yeah, I wouldn't worry too much about it. I think that if you're anything, like I said, anything done for educational purposes is probably okay. Anything done for nonprofit use is probably okay. You'd have to be careful about it. So if, for example, let's say you decide to appropriate someone else's mark or copyright, let's say the Black Lives Matter organization hires you and they say, as a designer, and they say, we want you to do a bunch of shirts that take these logos and do blah, 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 something with it. You have to be careful about that, because just because Black Lives Matter is a nonprofit organization doesn't mean they're not susceptible to being sued under copyright law. Copyright law doesn't care necessarily what your background is, again, it doesn't even really care if you're making money, because you might still be found to be liable under copyright law for that. So, educational purposes is one of those things where I'm like generally a lot more lax about it. I'm like, it's okay. You're doing it for class. You're not trying to make money off of it. You're not trying to really get it seen. It's just something you're doing as for class. That's okay.
Okay, great. Thank you. Our next question is about international rights. So, for example, if an artist in another country copies your work, is there any way that you can take legal action?
I mean, there are ways you can do it, but don't. You're not going to make any money. You're going to spend a lot of money. It's really hard. It's really hard to sue domestically to protect your rights. And the reason it's hard is because it's expensive, and it's actually, there's a bureaucracy you have to deal with. So just to give you some context, domestically, if you want to sue to protect your copyright, you have to register your copyright with the Copyright Office first. And then once that happens, you have to sue in federal court, and there's a whole process for suing somebody in federal court. And that's expensive, by the way, because you have to hire an attorney, and you got to go through that process, and you'll spend several $1,000s in at least 6 months of your life just going through that process before you even get the trial. Suing internationally is exorbitantly expensive, and the only people who do that tend to be big corporations, because they have the pocketbook to do that. So there are several international copyright treaties. Most countries in the world are signatories to them, which means like you can sue in China to protect your American copyrights, but it's so expensive that I can't imagine anyone can afford to do it.
Great, thank you. Deb has a question. What about using designer logos and making a painting or a photo that is commentary about overconsumption, so the logos themselves become symbols in a larger statement?
Yeah, I mean, on the face of it, it sounds like a permissible fair use, but I think you probably need to get a lawyer to write to you saying that it's okay to do that. I personally wouldn't feel comfortable just saying yes. I think you need to have someone agree to that. You need a lawyer to back up your initial instinct, but I think that sounds, based on the description, okay.
Okay, thank you. And Deb actually has another question. Is Instagram considered published?
Yeah.
Oh, that was good. Our next question is from Melissa. Melissa is wondering, can the rights to works made before 1922 be bought and then enforced, like old books being republished or rights to paintings or old photos?
No, but what they can do, for example, is, let's say there's an old Shakespeare book. Someone wants to take a Shakespeare play and do like an illustrated version of that. What that would be called a derivative work, that would be protected under copyright, but the underlying text would not be protected. Once it's in the public domain, it's in the public domain forever, or at least under current copyright law. I don't know. Congress would write a new law that did away with public domain. Then but there's no inkling that that's ever going to happen. So once it's in the public domain, it's free for all. In fact, I think Sherlock Holmes just entered the public domain last year, the year before. So at least in England, for example, I think it's still. I think the copyright for Sherlock Holmes in England still is on the books, but in America now anyone can do anything with Sherlock Holmes and not need permission from the Doyle estate.
Well, that's great, because that actually ties right into our next question. But how do you know if it's public domain?
You have to Google it.
Google. We like that answer. Our next question.
There's an online registry, and I don't have the URL off the top of my head, but there's an online registry where you can go and find out what's in public domain.
Great. Next question. Can an artist prohibit a buyer from ever reselling an original piece? And they're just asking because they didn't buy an original on Etsy.com for this very reason. It seemed unenforceable, but they're not sure.
Um, and it's not really a fair use question, but yeah. I mean, like, it really depends on the nature of the initial sale. So like if you're an artist and you sell to somebody and you say, I'm going to sell you my painting, but as part of the deal, you are not allowed to resell the painting. Like, that's something you could put in a contract. I don't know how enforceable that is. I mean, eventually, like, the original artist dies and the buyer wants to, make some money to retire on. I don't know how enforceable that is. Theoretically, it's something you can contract to do. Yeah.
Okay. This is a two-part question, so bear with me as I read it to you. This question is, I've heard that if you use someone else's photography as reference for a portion of your painting, it would be considered permissible because it's only a small percentage of a whole. Is this true? And if so, are there guidelines as far as what percentage is permissible or not for photo references used in paintings?
I really wish I could give you a straight answer, but the only thing I can say is see my previous presentation. It's there's just no definitive bright line answer to these questions. There's no point where you say, okay, I used 49% of the work, but not 50, therefore I'm okay from a fair use perspective.
Mm-hmm.
It's never going to be that simple. I think you always have to think about it in context and compare it to the other factors, and talk to a lawyer. I think that, and by the way, a lawyer will tell you whether they think this is fair use or not, but it's not a guarantee, right? Because, if you call me and you tell me your problem, and I say, I do the research, I do the analysis, and I say, I think this is fair use, and I write that to you in a letter. That gives you some backup, but it doesn't prevent you from being sued or having to defend yourself in court. So even me saying, yeah, I think it's fair use is still not, the bright line sort of defense you need. All it does is give you a little bit of extra backup, and it gives you some evidence going forward if you do end up in some sort of litigation. But, when it comes to reference material, again, I think the question is, it's largely contextual, or say the answer is largely contextual. How much are you using? How much are you copying it? How much of the final work is ending up in your piece? I had a designer, a cartoonist actually several months ago ask me this very question. And this person sent me, pictures of, like stock photos they were using. I actually wrote a blog article about this. You can find it on my website. But this person found, was using stock photos of like, chairs and people walking, just to get a sense of scale and size and position and pose. But ultimately the original works, the original stock photos were being edited out. So if this person wanted to illustrate a picture of a patient seeing a psychiatrist, they might use a picture of a stock photo of like a couch, so they could get the sense and like the position and scale of a couch. So they would draw the couch, delete the photo, then do the same thing with a person lying on a couch, so on and so forth. And I after looking at this person's material and looking at the original photos and the final work, I said, this is not a copyright infringement scenario. This is you're using these pieces as reference material, and that's permissible. But that was, again, it was a contextual thing where I had to look at their work and do an analysis for them. I couldn't just say, yeah, that's fine, or no, that's not fine.
Okay, thank you. I think your answer actually answered the second half of that question as well, so I will not go to that. I'll go on to the next one. This question is about illustrators. Are illustrators doing work for publishing? Like, for example, they're illustrating a children's picture book. Is their work protected by the publishing house? In other words, if someone wanted to sue for copyright infringement, would the illustrator or the publisher be on the hook, or would it both be liable? This would be the case of using easily identifiable photos for reference material for illustrations done in the artist's own style.
So the answer is, it kind of depends, but most of the time, in my experience at least, the client is ultimately the owner of the material. Especially like if you're doing illustrations for children's books, the book and the material and the work all ends up getting bought by the publisher. So they are the owner, even though they're not the creator. And so if someone was to allege copyright infringement, the the publishing house, the owner, whoever owns it, would end up being sued. You, as the illustrator, might theoretically get brought in as a third-party defendant because you were still part of that process, even though you were a freelancer or a contractor. Even if you're on staff, you would be brought in at the very least to testify, if not brought in as a defendant yourself. But if you're not the owner, you're probably reasonably safe from being sued.
Okay, great. Thank you. So at what point is inspiration not copyright? We see things every day, internalizing things we love, we hate, and that move us. And at some point, years later, we could do art that comes from something that has been percolating. How can any art be created without copyright?
Yeah, this is a problem. There was a famous copyright infringement case back in the 70s. George Harrison wrote My Sweet Lord, and which is one of my favorite songs of all time. And he was sued for copyright infringement for another song by a nobody band. And, you know, like George Harrison's argument was like, you know, I must have heard that song in the background on the radio, but like I didn't set out to infringe it or copy it. By the way, there's another song where I was like, oh, that's not close enough to be considered copyright infringement, but what do I know? The courts decided otherwise. But, you know, so it's an open question. There's no answer to that question, unfortunately. And I hate that that's the case, but it is the case. I mean, you could very well be inspired by something you don't even know, right? You could be inspired by something subconsciously, and you do the work, and then you're sued for copyright infringement. The only thing I could say is just be careful, do your due diligence. You know, understand that no work of art is truly original, I guess. And you know, be prepared to defend yourself. I think most courts tend to be fairly reasonable on these issues, but you know, there are certain industries where there are unspoken rules about infringement, fashion being one of them. The music industry is one of them. I mean, you know, it's very common in the music industry to sample the works of others and to take, you know, snippets and bits of the work of others and put it into your music. And the second somebody decides to upend that, I think it changes the music industry forever. It changes the fashion industry forever. And, you know, I don't know where the end result of that is. I think when you get to that point, the problem is big enough that it requires congressional legislation. But Congress lately is not seem all that interested in copyright stuff. So who's to say? I mean, the last time the Copyright Act was written in 1976, and there's been pretty substantial updates to the world and to culture and technology since then, but the Copyright Act hasn't been. So, you know, I don't know if you could ever expect Congress to legislate even an urgent problem like that. I wish I had a better answer for you, but the question and answer are bigger than me, unfortunately.
Yeah, that seems incredibly complicated. So our next question, I'm not entirely sure if this is a fair use question, but I am going to ask it anyway. We have the case of somebody who used to work as an editor at a production company, and they don't work there anymore. And they're currently applying for an artist visa. They have to show past work. They want to use the projects that they worked while they were at this production company for their application/portfolio. However, they're not formally credited anywhere online as an editor of these projects, and the company refuses to help them provide this proof in support of their visa.
Well, that's shitty.
What can they do? Yeah, exactly. You know, what are their rights? And
well, you know, so you always have the right to take credit for the work you do, unless you signed like a non-disclosure agreement of some kind. And even then, you still might be okay. But generally speaking, you always have the right to take credit for work you did, even if someone else doesn't credit you for it. And there are scenarios in which you may not be able to be credited, you know, especially if work itself is like top secret, you know, it's like classified or something. You know, I've had several clients who work in app development who have not been able to disclose that they worked on the app because it could potentially, you know, wreck the ability of this app to make money or whatever. I don't know. You know, it's just how it is. But it does happen, and so I would say unless you sign an NDA, you have every right to accept credit, to take credit for the work and use it in your portfolio. It is a right. to use the work in a what I call a non-commercial portfolio capacity, which is the work you did the work, you have the right to take credit for it, you have the right to tell people you did it, you have the right to put it in your portfolio and show that portfolio to prospective employers to gain employment. As long as you're not trying to sell the work itself, or you're trying to yeah, well, that's really it. As long as you're trying not to exploit the work itself, other than as a way to get you your next job, you are fine. Why they're not helping you, I don't know. Why they're not letting you accept credit for your work, I don't know. But I have a client right now who is a television production guy, and most of his work is online material, and the company he works for just doesn't credit people. So even though he's doing that work, there's no credit for him anywhere else online. So sometimes you have clients who are, for lack of a better word, shitty, mean people who don't want to credit you, but it doesn't mean you can't take credit for the work.
Great, thank you. Mara has another question about collage. So could you elaborate on the first of the 4 factors, purpose and character is transformed, in relation to using portions of a Disney character? An example is the work of Arturo Herrera. He used to cut up line drawings of Geppetto in many of his collages. The cut pieces were from an old coloring book, and his work was not a critique or a parody.
It's hard to make a judgment not seeing the work. And I would also say that different lawyers may have different opinions on this, but that doesn't seem to me to be a permissible use of the work, especially because it's not the purpose of the work is really important, right? So and what it's being transformed into, it's not just that it's being transformed, but what it's being transformed into is really kind of crucial to that analysis. And so without seeing it, it's hard for me to judge, but I think that that's always something you want to keep in the back of your mind. Why am I doing this? What is this for? Is this just to do it? Am I trying to find a loophole to somehow exploit another person's copyright? Or am I trying to do something original that comments on something that already exists? I think that's what I would leave you with. I don't know that I can give you a much clearer answer than that, because these analyses are so fact specific, and every single one is different than the other, even ones that share similar fact patterns and have similar circumstances. So, yeah.
Great, thank you for that. We have another question about renewing estates' rights. So, can an estate holding the rights of works renew those rights, even those made before 1924?
Well, they can't renew any right that is in the public domain. So once it's in the public domain, the owner has no rights to it anymore. It's done. I mean, they can still exploit it, but so can everyone else. There's no, what they lose is the exclusivity, the ability to be the only person to exploit that work. But in the United States, copyright lasts for 75 years, for the life of the owner plus 75 years. So if I do an original work when I'm in my 20s and I die when I'm 80, the copyright will last for 75 years past the initial 60 years I was alive. And then once that happens, it falls into the public domain. There was a period, God, it's been so long, I forgot when this was, but I think it was in the early 2000s, maybe the late 90s, when Disney was in danger of losing the rights to Mickey Mouse. And so Congress amended the Copyright Act to extend copyright ownership. So they could keep on exploiting Mickey Mouse and, the classic Disney characters. And, eventually they're going to near that again. Eventually, at some point in the near future, Disney's going to get concerned because, Mickey Mouse is about to fall into the public domain. And Disney, being a powerful corporation, will appeal to Congress. And Congress will probably act to extend the copyright life of Mickey Mouse and all other, and, not just Mickey Mouse, but all characters, so that the copyright term is longer. I'm personally a fan of reducing the copyright term to, say, like a flat 75 years. I don't think it's good for the culture for any one entity to own the copyright to something like Mickey Mouse for hundreds of years. But again, I'm one lawyer. There are a number of us who agree on that matter, but it's ultimately up to Congress. And I think that they're more likely to act in favor of the corporations and not us individuals.
I agree with that statement. So we have about 5 minutes left. We have 3 questions that we'd like to get through. So the next one is Carrie, from Carrie. Can a gallery be sued for selling an artist's work? Wait, excuse me one second. Can a gallery be sued for selling an artist's artwork with copyrighted images?
I'm not sure I understand the question.
I think that what they're asking is if an artist's piece of work is copyrighted, can a gallery be sued for selling that?
I mean, if without the artist's permission, yeah. I mean, they shouldn't be selling somebody else's work without the permission. If the artist, has a show at that gallery, theoretically they have a deal with that gallery to show their work and sell it. But yeah, I mean, you cannot sell the work of another person. One of the fundamental tenets of copyright law is that you have the exclusive right to own and to sell your own and to exploit your own work. And if somebody starts selling your work without your permission, then that's a pretty severe and obvious case of copyright infringement.
Great. Next question is about public art. So if a person takes an image of your public art project, for example, land art, and makes postcards or sells photographs of it while you did it for free, where does that fall?
That would be copyright infringement. So you are the owner of the art, even if it's public art, right? You're still the creator, you're still the owner, unless you somehow gift the rights to the work to the city or whatever. But you're the owner of the work. They are the owner of the photograph because they took the photograph. But the photograph is of a work that also has copyright attached to it. And that means that if they sell it, they are committing a form of copyright infringement called derivative work infringement. So they are making a derivative work, which is the photograph, without your permission, and then exploiting it and selling it also without your permission. So even though they own the copyright to the photograph, they don't owe the copyright to the underlying artwork, which is yours. So yes, that would be copyright.
Wonderful. And Melissa has a question. We have a quick follow question related to permissions about usage of images as a portrait artist. If a person's face, I think this is going back to what we asked before, but if a person's face is in a photograph and a person has permission from the photographer, do they also need a separate permission from the person depicted if their face is recognizable? Thanks so much. This has been very helpful. Thank you, Melissa.
Yeah, you might. But that's not a copyright issue. It's a copyright issue if you're using a photograph as source material for a painting, then yeah, the photograph itself has a copyright, and you would need if you plan to take that painting and like sell it in a public marketplace or something like that, then or exploit it and put it on t-shirts, yeah, you need the copyright ownership. You need the rights to that photograph. But for the person whose image that is, you would likely need, it's not a copyright issue, it's a invasion of privacy issue, actually. You would need permission to use their face and likeness if they haven't given it to you already. So that's something you see often in like the film world, when you're interviewing people on the street. You need their permission to air footage of them, because it's their name, it's their face, their likeness, and you have a right to exploit your own likeness any way you see fit.
Right.
So in that case, you would need several different types of rights. You would need the rights of the likeness rights of the person whose face it is. You would need the rights of the person who took the photograph, or the owner of the photograph, and so to make the painting and then exploit it. But if someone hired you, for example, to do like a portrait, and they were going to hang it in their house, and so you said, okay, well, my friend is a photographer. She's going to come to your house and take the picture, and then I'm going to use the picture to paint your portrait. I mean, there are still rights associated with the photograph and the likeness rights, but because you're only going to give that painting back to that person to hang in their house, it's a non-issue.
Okay. I know I'm trying to be cognizant of time. I want to wrap up these last 2 questions. Is collecting images from the internet to serve as private inspiration, like how does that work? They're referencing Pinterest, where one can collect images from major image producers like Nat Geo and etc.
I think you're probably okay, but you always just have to be cognizant of how much of a given work you're bringing into your own. That's all.
Okay. And Carrie just wanted to circle back. She is clarifying. I mean, if an artist's work has imagery from another artist's copyrighted artwork, like a Disney character in it, can the gallery selling it be sued?
Yeah. Again, if they don't have the rights to do it, yeah. I think. Well, okay. I see what you're saying. So you have a deal with, you're the gallery owner. You have the deal with an artist. Their art contains copyrighted or what appears to be copyrighted work that's belonged to somebody else. Can you, as the gallery owner, be sued? That's a good question. I don't know, but I don't think so. I'd have to look into that a little bit closer to get a better sense. I don't work with a ton of gallery owners myself, but you're not the infringing party. As a gallery owner, you're a facilitator, and you might be brought in if there was a lawsuit, for example, as a witness, or to testify. But I don't think you're on the hot seat because you are not involved in the rights. You just have a deal with the gallery owner, and you just have a deal with the artist, and the artist theoretically is saying, yeah, I'm the original owner of all these works, so I have a right to sell them here, or I have a right to let you sell them here. So I think you're probably in the clear.
Okay, great. Thank you. That's the end of our questions. So Greg, thank you again for taking the time during your day to chat with us. We've already received some pretty amazing feedback on this. So, and C5 just asked me, yes, you will have access to this presentation afterward. We will be posting a recording of this on the alumni website. It does tend to take anywhere between 7 to 10 days for us to get that on the website, but I'd keep your eye on it. And if you don't see it, feel free to send me an email. And that is it. Thank you everybody for participating, taking the time to be with us today. I encourage you to keep an eye on your emails. We will have additional webinars and panels from the Alumni Relations Office coming up, and we would love for you to participate. And if I may just give a quick little plug, if you haven't already checked out our alumni student mentoring platform, it's called the RISD Network. It's a wonderful place for you to connect with current RISD students as well as connect with your former classmates. So again, if you have any questions about that, feel free to reach out to me. And I'd like to say thank you one more time to Greg, and I hope you all have a wonderful day. Take care, everybody.
Bye, everyone. Thank you.
Bye-bye.